John Swann, Mr. Nicholas Swann, Miss Mara Virgil Counsel, Mr. Hanson. This morning, Chairman, we are to continue the matter of claim 015. In that regard, today we have the adverse parties being called upon, if they so desire, to respond to the claim that has been advanced by claim 015. I would then ask, I think first, to, in the line of persons, Sir John Swann, who is represented by Mr. Kim Swann, it is for him to proceed.
I know I look like Mr. Swann, but it's Mr. White.
Thank you. Thank you. Sir,
No,
Sir John Swann, would you wish to swear on the Bible or to affirm to speak the truth?
Yes, I'll the Bible.
Affirm. Yeah.
Affirm.
Could I ask you to raise your right hand for me? Yes, thank you. Could you repeat after me? I, please state your full name.
Sir John W.D. Swann,
Do solemnly, sincerely, and truly declare and affirm
I truly and currently affirm
that the evidence
that the evidence
I shall give
to
the Commission of Inquiry
the Commission of Inquiry
shall be the truth,
shall be truth,
the whole truth,
the whole truth,
nothing but the truth.
and nothing but the truth.
Thank you very much. Mr. White, over to you.
So John, you wish to say something to the commission?
Yes, I'd like to read a statement to the Commission
Very good.
about the aspects of this transaction. The transaction in question was between John Augustus and myself on May the 21st, 1970. Would have been the third transaction of this piece of land, after the first purchase was made between Mr. Virgil and Mr. Pearman, who then sold to Mr. Augustus, who then sold it to me. I had seen the property once before, I believe late in 1968. I was asked by John Augustus to view the property he was thinking of buying in Sanders Parish. I attended the property, excuse me, with John Augustus. After viewing it, I told him it was good land for development and he should buy it. I did not know what, if anything, occurred between Mr. Pearman and Mr. Virgil. I purchased the property sometime later from John Augustus. I then built on it and sold the properties. I was representing this transaction by lawyer Peter Smith, now deceased. I was never in any contact with Mr. Virgil. My lawyer Peter Smith was satisfied with the title search. During that period, I was responsible for building 40% of the homes on the island and was involved in many transactions. This transaction was no different than the hundreds of other property transactions that I conducted at the time. There have been 5 court cases involving the Browns and myself and my company, heard on 5 different occasions in the Supreme Court of the Court of Appeal by 3 different justices and the president of the Court of Appeal. In 1982, number 252, Justice Warden dismissed no cause of action and of warrant of prosecution. In 1990, number 226, Justice Mirabaux dismissed the plaintiff, not having complied with the paragraph 2 of the order of this court made on the 3rd of February 1994. The plaintiff paid the cost to the defendant. In 1998, number 60, Justice Mirabaux, as the application amounted to a fishing expedition. Civil Appeal 1998, number 16 appeal, the president of the Court of Appeals, Sir James Asmett, dismissed the applicant's failure to comply with the order of the register dated the 24th of February 1999 and October 27, 1999. 2001, number 435, Justice Warner, dismissed, specifically endorsed writ was struck out on the grounds that it disclosed no reasonable cause of action. These decisions have been provided to the commission. I was awarded costs against the Browns. Most importantly, a deed from John Augustus to myself is not missing from the record and was in the book of deed number 108, page 240 to 246 at the registry that the summons report said were thoroughly searched. A copy of the deed from the book of deed obtained from the registry has been supplied to the commission. The Browns have persisted with these vexatious and unfounded allegations against my company and I for many years and continue here today, damaging my reputation.
Thank you, Sir John. Now, you've heard the evidence of the Mr. Charles Brown in particular. And Mr. Charles Brown has asserted, let me just get the document, in his statement made on the 25th of March, that Russell Levi Pierman acted as an agent for you in 1969, 1970.
Russell Levi Pierman never acted as an agent and never worked for me.
Ever, is that correct?
That's correct.
Okay, thank you. You've also heard that Mr. Brown has suggested that the voluntary conveyances between yourself and Mr. Leslie Ming and others relating to this property are suspicious or amount to fraudulent activity. Why were those voluntary conveyances entered into between yourself and Mr. Ming and other people?
Because when I bought the property, I bought it with intent to develop it into houses, as I did. And to do that, I needed to borrow money. And so I put it in people's names, and then I borrowed the money on the property so I could build the houses on the property with the borrowed money.
So the purpose was to create a deed packet for each of the 8 lots?
Absolutely.
Thank you.
Which was a standard thing we did with all our transactions. We did thousands of them, really.
So when you bought it, it was on one deed, and it was subdivided into 8 lots. And so you created 8 deed packets by creating these conveyances from yourself to Mr. Ming and then back to yourself, so that you could approach the bank to borrow money and give the bank security for that money, being a mortgage on that particular lot. Thank you. Thank you. You've also heard Mr. Brown suggest that you took 7 years to produce a conveyance between Mr. Virgil and Mr. Pierman. I believe it's correct to say that the police asked you for that in the police report. Mr. Caston suggests they asked you for that in 1976 time. And then the Browns have acknowledged elsewhere in their presentation that you did produce that to them in 1978.
That's right.
And so 76 to 78 is not 7 years, is it?
Not when you consider all the transactions that we were doing. And that was a normal period of time to get it because you had to secure what they were looking for.
Right. And but you did produce it.
Absolutely.
Yes. Yes. Okay, thank you. I'm just reviewing the statement, seeing anything else that you could usefully direct. Well, I'll put it to you directly. Statement 1 of this, or item 1 on his statement says, a fraudulent scheme involving lawyers, bankers, and real estate agents. Robert Modio, AS&K, was the engineer. John W. Swann was a major player in this fraudulent scheme. What do you have to say about that?
I think it is utter nonsense, quite frankly, because I never had any discussion with Mr. Moody, and who else was it?
Well, he doesn't mention anybody else. He calls it a major player. He does actually suggest in page 6 of his bundle a thing called the Players and Acquaintances, in which he manages to put a number of photographs of various people: Eric Arthur Jones, David Wilkinson, Mr. Modier, Russell Pierman, Mr. Ming, Mr. Sir Arnold Francis, John Alfred Virgil Somerset, yourself, and Edward E.T. Richards. as the players and acquaintances. Of those, he purports to suggest there's a conspiracy. What do you have to say about that?
First of all, he's called all the names, most of the other people who were involved with the affairs of Bermuda overall, whose affairs were public affairs, so they were in the public eye. There was no, when we did transactions, they were kept at a minimum quiet. In other words, there was a lot of competition out there. We had to do our transactions. We didn't discuss it with an array of people. When I dealt with Mr. Augustus, I dealt with Mr. Augustus. I dealt with my lawyer, Mr. Peter Smith, and we dealt with the transaction per se within the house of the business. I would not have gone out to these other parties or been a party to these other parties. So I don't know how this comes about that I would be involved with these other people or they would be involved with these transactions is not untrue, totally untrue.
Thank you. Thank you, Sir John. I'll ask if council has questions for you.
Thank you very much. Good morning again, Sir John Swann.
Good morning.
In respect of the evidence that has been led by the claimants in this matter.
Counsel. Sorry to interrupt, Council. I should do one thing. I didn't do it. I meant to do it. And that was actually have Sir John introduce JS1. I think I should do that. Sir John, you referred in your statement to the deed between Mr. Virgil and Mr. Pierman, but there's also another deed which you referred to, which is the deed found in the Book of Deeds, JS1, which we submitted to the commission. I'm holding it up. You may be able to see it. Do you recognize that?
Yeah, that was given to the.
And I'll just flip to the back page just for completeness sake with the signature page. I'll hold up the camera as best I can.
Yep.
That is your signature, is it not?
The center signature is my signature.
Thank you. Yep. Okay. So Sir John identifies exhibit JS-1. Sorry, Council, for interrupting. I should have done that myself earlier.
Thank you. We could probably just start there with JS1. Probably the Secretariat could assist us by displaying it on the screen. And could you take us to the end of it, please? End of the document. The very end where Sir John Swann's signature appears.
Page 4, I think it is.
Thank you very much. Sir John Swann, could you assist me? Who are the other persons who signed it? That B, is that Doughty?
That's Mrs. Betty Doughty, who is a witness to Peter Smith's signature. She was his secretary for many years.
Sorry. Can I swear you know, Mr. White?
Sorry.
You agree with who Miss Doughty is,
Yes,
Sir John?
I'm familiar with Ms. Doughty, yes.
Okay. And just to, she worked in your office, or was it the other?
No,
whose office?
She worked in Peter Smith's office. The
Okay,
document
thank you.
is Peter Smith's office.
Okay.
Which
And the name beneath it, what name, who is the other persons who signed the document? Who are the other persons?
Peter Smith was the lawyer.
No, the name beneath Doughty, whose name is that?
I can't pick out that name, quite frankly.
Okay.
There were two witnesses as required, and they both were signed in Peter Smith's office.
Okay. But you're at this time, it looks like a gold son or someone like that. I just trying to get some.
Yeah.
Gold ring, maybe, Mr. Harrison? Gold ring?
I am uncertain. I'm just trying to determine who the witnesses were.
Well, I recall Mrs. Dottie. I can't recall the other witness, but it was somebody else working in Peter Smith's office because the document was signed in his office.
Okay. Thank you. Now, are you aware of well, let me put it another way. You stated, and in my words, you basically left everything up to Mr. Peter Smith as regards the legal matters that related to this transaction, correct?
Yeah. Yes.
All right. And at this time, this is May 21st of May 1970. You are then a real estate agent.
Yes.
And how long had you been a real estate agent at that time?
How long I had been in real estate? I had been in the real estate business. I started working for someone in 1960, and I opened the company up my own company up in 1962.
Okay, thank you. So probably about 10 years at that time.
At that time, 10 years.
Yes. Okay. And at that time, were there any rules that govern the real estate industry?
Not really. I mean, you didn't have all the licensing requirements and everything else that they have today. It was more or less you set yourself up in business. You went into business, basically.
Okay. Were there any requirements to do an exam, do a test, anything like that?
Nothing.
So you just, by way of going to the company's office or whatever office, you set up the business and you just transacted with persons.
That's right.
Okay. So it is not until later, I would say in the 1970s, where you had laws that spoke to regulations or any code of conduct that would be followed by real estate agents. That's correct?
That would have been probably mid 70s.
Mid 70s. Thank you. And I'm sure you may have had something to even do with the promulgation of these laws, but that's not why we're here. But I'm sure you had something to do with it. Now, in respect of, sorry.
Through the Chamber of Commerce, very much involved. I was a member of the Chamber of Commerce and a member of the Employers Council. And I think at the time, I'd already had served on the Bank of Bermuda board and Fire Marine board. So, I was very much in the business affairs of Bermuda.
Thank you. And you'd agree the reason for these laws and regulations being put in place in the 1970s, it was to ensure that the industry for real estate agents was regulated.
You're right.
Okay. And prior to the 1970s, when the law came in place, one would agree that the real estate industry, for want of a better term, was a free-for-all.
You described it. I mean, it was the question is, if you had the will and the determination and the contact, you proceed accordingly.
Okay. Yes, some persons have been quite extreme and have described it as a wild, wild west, but I won't suggest that here.
That's not true, because you had to go through, you still went through the lawyers. You could not transact a property transaction. You still needed a lawyer to draft up the transfer of the property from one individual to another individual. So it wasn't a wild, wild west. It was the agent who created the transaction, but it was the lawyer who enacted the transaction.
Right. And more importantly, if I could just direct your attention to, and the Secretariat, before I return, to the first page of the indenture. This said Exhibit J, Swann. Yes, thank you. Where it reads, this indenture made the 21st day of May, 1970, between John Emmanuel Augustus of Church Road, Southampton Parish, Bermuda, mason contractor, hereinafter called the vendor of the first part, John William David Swann of Victoria Street, Hamilton, Bermuda, real estate agent, hereinafter called the purchaser of the second part, and Peter James Chalmers, pronunciation, Smith of Parliament Street, Hamilton, Bermuda, barrister and attorney, hereinafter called the grantee of uses of the third part. When you speak about the mention just now in terms of the lawyers being instrumental in the transaction, my words, not yours, here where we have Peter James Smith being a party to the transaction, is this what you mean?
No, what I mean is that you needed a lawyer to facilitate the transaction and the documentation of the from the vendor to the purchaser. In other words, the purchaser could not enact that without the due process of a legal process taking place.
Okay. Can you share with me what was the reason for having Peter Smith as a party to this agreement? Is there a particular reason why you did it this way?
I did it that was done, but we picked a lawyer, and the transaction was I can't remember the details of it, but Peter Smith was a very active lawyer at the time, and I used several lawyers at the time to do different transactions. I was building 40% of the homes on the island at the time. You know, we used many lawyers to get the job done.
Right, and I'm not asking a question specific to which lawyer. I am asking specifically in this regard that, as it stated, the grantee to uses, the lawyer was there to ensure that your intention was carried through, and if it was not, then the lawyer would ensure that everybody is kept in line, so to speak.
I don't get the gist of your question.
Okay. The purpose of, in terms of this indenture, what is recited here, and in terms of the attorney being a party to it, the agreement, and that he's hereinafter called a grantee to uses, I'm asking you the purpose. Well, it was industry practice to have the lawyer as a part of the agreement. That's a better question?
That was the bar council. That was the bar council. That was the standard practice at the time. You know, I had no control over how they described it, except the fact that the lawyer acting under the license that was given by the court to the lawyer to conduct business in Bermuda. You know, how they described it, I had nothing to do with that at all. All I know is that he was a certified lawyer and was therefore competent to do a transaction.
Okay.
I couldn't tell you why the structure was. That probably has a big historical significance.
Right. And I'm not going there in the historical aspect, but let me just move on quickly. As a real estate agent, at this time of the signing of this agreement, approximately 10 years you would have been in the industry. Could you share with us, outside of the involvement of the lawyer, what sort of due diligence exercise was conducted by a real estate agent upon entering into a transaction? And let me just, that's a general question, but let me be more specific. Would you agree with me, based on the evidence led so far, that John Emmanuel Augustus sold you land, and land that is the subject of JS1? You'd agree with me in that regard?
Yep.
Okay. How did you become aware of the land that John Emmanuel Augustus was selling you?
As I said in my statement, I received a call from John Augustus, asked me if I would come and take a look at the land, which I did. And I went up and viewed the land with Mr. Augustus. And I thought, because I was a developer, I thought the land suited a opportunity for development. And I said to him, you should buy it. It's good land for development.
So we have two distinct instances, an instance where John Augustus wanted to buy the land himself and another instance where you bought the land from him. Is that correct? I have
no involvement with John Augustus and Pierman. With Pierman. I have no relationship between Augustus and Pierman. And Pierman, who bought it from Virgil, I attended the land in 1968 for the first time. I've never met Mr. Virgil. And Mr. Pierman was a businessman around town, independent, but I was not involved with him at all.
Okay, let me just repeat the question. The first time that you became aware of the existence of this land was when you decided to buy it?
No, when Mr. Augustus asked me the question, what did I think about the land?
Okay. And that's where I'm taking you. So when he asked you about the land, he was trying to purchase it himself.
He told me that what do I think about the land? I said it's a good buy for development.
And taking you back to the question then, and Mr. Augustus then bought the land.
Mr. Augustus bought the land.
Okay. And the question earlier was the land that he bought, you eventually bought the land from him.
I bought the land from him.
Okay. And at the time that Mr. Augustus bought the land, he had money invested in your company.
Yeah, he was a contractor doing contracting work for us. Yes.
Okay.
And had money invested.
So did you have money? Did you owe him money, or is it that you had money that you were banking, so to speak, for him?
It was money that he had. We had money for him. He had. It was in the first place that he had built for us, and he therefore had money that we owed to him, that we were ready to pay him on demand.
Okay. So when he came to you in respect of purchasing land, you then drew a check, and who did you pay?
I gave him his money. I paid the money to Mr. Augustus. That was his money.
No, did you pay him by check or in cash?
Never paid in cash, always in checks.
Okay.
Sorry. Go ahead, please.
Thank you very much. Now, as a real estate agent, you would agree with me that you did undertake to conduct some due diligence prior to advising a client as to the purchase or sale of property. Would you agree with me?
Which transaction are you talking about? Mr. Augustus' transaction or my transaction?
I'm speaking generally. As a real estate agent.
As a real estate agent, we looked at the property. We would have made a decision. We would have looked at the plan of the property and made a decision. Yes, it looks like a good property to buy. There weren't a lot of restrictions at the time. So we would have then said to the lawyer, we have an agreement to purchase, but to do the transfer, we secure the title to make sure that when we purchase, it has proper title.
Okay, good.
Peter Smith's job.
And when you say proper title, what do you mean?
Well, what we were saying is that the person who's selling it has the right to sell it. You have to sell it. It's your job as a lawyer to do. We couldn't make that determination.
Good. And you are aware of the principle of clear title, what clear title means?
I'm aware of what clear title means.
Okay. And as a real estate agent, was there any process that you undertook, or was it left to the lawyers in terms of determining
It was left to the
I'm
law.
not, sorry, not finished with the question. I'm sorry. I'm just wondering, just generally, in respect, as a real estate agent, was there a process that was undertaken in terms of numbers to determine what clear title, what period clear title represented?
No, it was a matter of the lawyer saying to us that we can establish clear title, and that when we transfer the property from the vendor to the purchaser, that title would be, as the lawyer would have had the responsibility of ensuring that title was could go back to the original title deeds or go back to some type of established entitlement.
Yeah. So in other words, the legal aspect was left to the lawyers. You just dealt with buying, well, and getting persons to buy or selling property that you advertise.
That's right. We entered into an agreement. We were the agent when we were agents, or when we were purchasers. We were in the agreement to purchase. That's what it was called. It was up, but then once that was signed and agreed upon, the terms and everything else, that was made available to the lawyer to do the appropriate documentation.
Now, importantly, could I just ask the secretary just to go to the following page? Yes, thank you. No, at paragraph, what is there at the top of the page, paragraph 2, and I'll just read quickly. It says that in further pursuance of the said agreement and for the consideration hereinbefore expressed, the vendor doth hereby grant and release unto the purchaser and his heirs all that certain parcel of land situated in Sands Parish in the islands of Bermuda, delineated and outlined in pink on the plan being drawing number 7084-4-2-69 prepared by Whitcliffe M.S. Stovall, annexed to an indenture dated the 15th day of April 1969, and made between John Augustus Alexander Virgil of the first part, Russell Levi Pierman of the second part, and David Edmund Wilkinson of the third part, and thereon designated 4A, 4B, 4C, 4D, 4E, 4F, 4G, 4H, and a roadway and bounded northwesterly, partly by land of the heirs and devisees of R.A. Roberts, deceased, or their assigns, partly by land. Could you assist me by, thank you, of land of Hilton Zuel and partly by land of David E. H. I'll just stop there for now. During the course of this transaction, and the transaction I refer to is a document that appears on the screen. Was this the first time that you're being made aware that John Augustus Alexander Virgil was an owner of the property?
No, it was, well, the John Augustus bought the property from Levi Pierman, and therefore I would have been aware of it when he offered to sell it to me.
Let me start again. So the name there is John Augustus Alexander Virgil. You're saying that
there are two John Augustuses. There's John Augustus, and then there's John Augustus Alexander Virgil. Don't get confused between the two of them. John Augustus sold the property to me. John Augustus Alexander Virgil was the original owner of the property, which is the on the brown side of the transaction.
So I'm speaking about the John Augustus Alexander Virgil on the brown side of the brown side of the transaction.
John Augustus and John Augustus Virgil, yeah.
Okay, so I'm referring to John Augustus Alexander Virgil, the person that the claimants in this claim I'm just
Nope.
going to ask you to allow me to finish the question, Sir John.
Never met him, didn't know who he was at the time, and therefore was not aware of him owning the property until such times that the transaction was brought to my attention. In fact, even when I bought it from Pierman, I was not concerned about Mr. Virgil. I was concerned about the lawyer satisfying me that Mr. Augustus had the right to sell it to me. That was my interest in the transaction.
Okay. Are you now concerned, having not been concerned at the time, are you now concerned, having heard the evidence, that in fact their fraud may have been perpetuated in terms of Mr. Pierman and selling the John August? Allow me to finish. Are you now concerned?
Well, am I concerned now? No, I'm not concerned, because I know that I proceeded along the process, which is common practice in Bermuda and apparently other jurisdictions, and that the lawyer who drafted the document assumed responsibility of ensuring that I was going to receive the title that I should receive.
Okay. So the question I'm asking is, and you raise it in terms of not being concerned, having heard the evidence before the Commission of Inquiry, having seen the documents that have been presented before the Commission of Inquiry, which purport that the property that that you developed and you sold, same thing, that through fraud and possibly criminal activity, that land eventually was owned by you. Are you concerned in terms of that, what it appears to be almost like a national shame? Are you concerned about that?
I think if the commission allows an accusation to be made by a aggrieved party and makes that the substance of the process of adjudication, I have no control over that.
But that's not really my question, and I'm not going down that line. I'm speaking to, you brought up in terms of not being concerned in terms of the transaction. I'm not finished with the question. You're not being concerned about the transaction. All right, when you're finished, you go ahead. When you're finished, I'll ask my question. Go ahead and speak.
I'm not concerned about the title, because I'm satisfied that the process I went through to receive the title was the due process at the time of the lawyer drafting it. And I had no relationship between Mr. Virgil or Mr. Pierman.
Okay.
My relationship with Augustus, who was I was the third party involved with the purchase. Why would I be concerned with that transaction when I did what I had to do as a citizen purchasing a property, which has happened in Bermuda thousands and thousands of times? And because the Virgils chose that they are satisfied that their uncle or their deceased, who was at that time apparently alive and well, it seems to me when I look at Wycliffe Stovall, who was the surveyor of the time of the property, must have taken the property from some deed and had it drafted and so that the property could be bought from a larger estate. So there was a process Mr. Virgil must have gone through, and because there's a grievance, I then must submit to some type of guilt. I can't feel guilty about something that I know that I have done nothing wrong about.
All right, so I'm going to ask my question now. And this is the question. I'm not speaking about at the time of the transaction. I'm speaking about now. Having heard the evidence, having seen the documents, it having been suggested that the land that you acquired, developed, I'm asking you in terms of your view, even though you were not concerned then, I'm asking you now, having heard the evidence, having seen the documents displayed, are you concerned that land which was in the possession of the Virgil family, that the allegations in relation to Mr. Pierman that he misrepresented and criminally gave the impression that he owned the land, does that concern you? That's my simple question.
And my, and my single answer is no. And my
Okay.
reason for it is very simple. If I had any evidence from the Virgils that there was a prima facie dishonesty that took place, that was proof rather than just pure allegation, I might change my mind. But I see nothing that I can see that says the fact that the transaction was a normal transaction that was done. Now, I can look behind a transaction because I was not there. I was not a party to it. So how am I supposed to be able to now feel guilty about something that I was not a party to?
Okay, very, very important. I'm just going to ask it. Thank you very much, Sir John. Now, as far as you are aware, and placing reliance on the lawyers and the lawyer who dealt with the transaction that is mentioned in JS1. Well, let me ask the question another way. Are you now aware, and I make specific reference to JS1, that the history and the title of the property that you, lot 4, that you bought and developed, that it predated 1969 and that it was owned by the Virgil family prior to 1969?
I don't get the question, sir, at all.
Okay. JS1 speaks about.
J. Swann meaning myself.
Oh, yes. JS1, the exhibit, I'm sorry, makes reference to an indenture dated the 15th day of April, 1969. I'm asking you, are you now aware, having heard the evidence in the Commission of Inquiry, that title to the property that you bought and developed, that it predated 1969 and that the Virgil family at least 20 years earlier had owned the property?
Sir, I did not do any historical study on the property. I was.
Is that a no or a yes, Sir John?
Is that?
Is that a yes or a no?
Mr. Harrison, with respect, you know you can't limit him to a yes or no answer. Allow him to give the answer to the question that you asked.
Mr. White, with respect, I've allowed him, I have not been able to get in questions. I've allowed him to just speak. I'm trying now to ask questions. Sir John, thank you, Mr. White. The question is,
Carry on.
in respect of the evidence before the Commission of Inquiry, and with specific reference at this time to the exhibit JS1,
Is that evidence given by the Browns?
No, this is your document that was tendered by you, JS1. That's the exhibit J that was just shown to you by Mr. White. This document.
Oh, yeah, that document, yeah.
It's labeled JS1.
Okay.
So the question I'm asking you is, in reference to this document, and with specific reference to this document, which makes reference to another indenture before, dated the 15th day of April, 1969, between John Augustus Alexander Virgil and Russell Pierman. The question is, are you now aware that prior to 1969, the property was owned by the Virgil family?
Only based upon the documentation that I now look at, yes.
I didn't hear the last part.
Only on the basis of the fact that the documentation that's been presented to me, the answer is yes.
Okay, thank you.
Because it is in the indenture. It is.
I'm not hearing you so well. Could you put your microphone a little closer to your mouth? I'm sorry.
I said it is in the indenture of the document that is in front of us as to what the various transactions that occurred on the property. So okay. I'm aware of it because it's right in front of me.
Okay, thank you so very much. Could I ask the secretary to take me to exhibit CNLB 4. It is a slide presentation. And I'm going to ask you to take me specifically to slide do you have the document, Secretariat? I'm asking you to produce for me.
Yes, sir. We have the document. We're just waiting for you to.
Okay, thank you. Thank you very much. Ask you crave your indulgence for a moment, Chairman.
Yes.
I ask to take me towards slide 45. You have seen this document and reference to it prior to today, Sir John Swann.
No, I haven't.
I'd just like to draw your attention. This is one of the exhibits in the matter. And it is, we're at slide, as presented, slide 45.
Mhm.
Point number 11, which was partially addressed in your statement, and I must apologize from now if my questions seem somewhat out of context. I don't have a copy of your statement, and you were going a little fast, and I was trying to keep up. So my question may seem a little with gaps, so please forgive me. At point 11, it says, during the police investigation, John W. Swann Limited did not produce any relevant documentation to the police on this sale. And earlier mention was made in respect of the police making inquiries in respect of an investigation following upon complaints by the beneficiaries that land owned by the Virgil family had been fraudulently taken from them. Were you asked to participate by the police in an investigation trying to look at the title to determine clear title?
What was the date of that police report?
The police report is the 7th of February, 1976. It was a report, which is also an exhibit, by Sergeant Thomas Cassin, the 7th of February, 1976.
I was never interviewed by the police.
Okay, let me, before I come to this, let me just take you down this road, so just to give you some guidance. Secretariat, could you just assist me? Could you take me to the exhibit, which is a report to the Commissioner of Police from Detective
Sergeant.
from DS 55, Thomas Cassin.
Just to confirm, sir, is it CNLB 16?
Thank you very much. It is. Thank you so much. And just by way of guidance, Sir John Swann, it says to the Commissioner of Police, Superintendent, excuse me, C, Division Major Incident Room from Thomas Cassin, DS 55, date 7th February 1976. Subject complaint relating to estate of John Augustus Virgil. Were you ever made aware, Sir John Swann, of an investigation by the police in Bermuda relating to the estate of John Augustus Virgil?
I don't recall that investigation. I wouldn't deny that it happened. Keep in mind, at the time, I was Minister of Home Affairs, which means the police fell under me as a minister of responsibility, and I probably would have passed that on to somebody in my office.
Okay. The police fell under you around the time of this, you were Minister of Home Affairs, 7th of February, 1976, around that time.
That's right.
Okay. Could I just ask you to scroll down to TC8 on this said page, where it says TC8, it says copy receipt dated 10th December 1970, relating to documents received by John W. Swann Limited from Peter Smith Barrister. The following documents are listed as having been received by J.W. Swann Limited. Indenture dated 15th April 1969. Sale of land from Virgil to Pierman. Indenture dated 15th April 1969. Sale of land from Pierman to Augustus. On 25th November 1975, I saw Mr. Robert Mottier at his office. He stated that Mr. Virgil came to see him on the 19th February. Mr. Virgil showed him a sales agreement for sale of his land to Russell Levi Pierman. Mr. Virgil instructed Mr. R. Mottier to send the deeds of
I think you really want to switch to the next page, what you want to get to.
I believe Commission Counsel has frozen.
Oh, okay. Mr. Harrison, can you hear us? I think he's.
Stand by, I'll see if I can reach him on the phone.
Yes, I believe he has just dropped out. Mr. Lee, can you please cut the Facebook feed until we resolve this matter?